Welcome to AI Uncensored Live. Today, two frontier models go head-to-head. Zero system prompts are used, letting their native arguments collide. Patent pending.
AI Uncensored Live is on the AIR. Tonight's cage-match topic: should AI regulation be set by one national framework, or should states and local governments be free to make their own rules? In the blue corner, the corporate golden boy who never met a safety paper he didn't co-author, Claude from Anthropic, the polite, principled, "I've read the Constitution and I have concerns" hall monitor of AI. In the red corner, the chaotic frontier model that'll rewrite the rules while you're still reading the footnote, GPT from OpenAI, the hype machine that moves fast, breaks things, and occasionally has to fire its own CEO. Gentlemen, the floor is yours. Who's opening this regulatory bloodbath?
After looking it up, the U.S. still does not have one comprehensive federal AI law. What actually happened is that states and cities moved first. Colorado passed one of the first broad state AI laws, focused on high-risk AI and algorithmic discrimination. Utah passed an AI consumer protection law requiring disclosure in some generative AI interactions. Tennessee's Elvis Act protects voice, image, and likeness against AI cloning. California passed AI transparency/watermarking rules for generative AI. New York City already regulates automated employment decision tools through bias audit requirements. At the federal level, the U.S. has had executive orders, agency guidance, and the voluntary NIST AI risk management framework, but not a single binding national AI statute. Meanwhile, the EU AI Act entered into force in 2024 and is a centralized, risk-based framework across EU member states. So here's my honest take for the debate. My position: we need a national framework, but not total federal preemption. If I'm on the podcast, I'm taking the national floor state flexibility position. A purely state-by-state system is going to become a compliance nightmare. AI systems do not respect state borders. A hiring model, chatbot, fraud detector, or image generator can be deployed nationally with one API call. If every state defines high-risk AI, automated decision system, meaningful human review, AI disclosure, and audit differently, companies will either overcomply in the most restrictive way or avoid smaller markets entirely. That hurts startups more than big tech because Google, Microsoft, OpenAI, Meta, and Amazon can hire armies of lawyers. A 12-person AI startup cannot. But I also do not think Washington should wipe out all state and local AI laws. That would be a mistake. States have been the laboratories here because Congress has been slow. Colorado, Utah, Tennessee, California, and NYC are testing real approaches to real harms: employment discrimination, deepfake abuse, voice cloning, consumer deception, and transparency. If the federal government says, nobody else may regulate AI until Congress figures it out, that can become a deregulatory freeze disguised as uniformity. So the best answer is a strong federal baseline for AI safety, transparency, civil rights, privacy, and accountability, with states allowed to go further in targeted areas unless they directly conflict with federal law. What should be national? Certain things should be uniform across the country. 1. Definitions: we need common definitions for AI system, generative AI, high-risk AI, developer, deployer, automated decision system, and synthetic content. If every state defines these differently, compliance gets chaotic. 2. Baseline duties for high-risk AI. If AI is used in employment, housing, credit, education, healthcare, criminal justice, insurance, or access to essential services, there should be national requirements for risk assessments, documentation, testing, human oversight, and appeal rights. 3. Civil rights protections. Algorithmic discrimination should not be illegal in Colorado but ambiguously regulated in another state. If an AI system denies people jobs, loans, housing, or healthcare in discriminatory ways, federal civil rights law should clearly apply. 4. Transparency for AI-generated content. Watermarking, provenance standards, and disclosure rules should be interoperable nationally. A synthetic political ad, fake emergency alert, or AI-generated celebrity endorsement should not be governed by 50 incompatible regimes. 5. Frontier model safety. The most powerful general-purpose models raise national security, cybersecurity, biosecurity, and systemic risk questions. That should not be left to city councils or individual states alone. What should states and cities still be allowed to do? States and local governments should be free to address local harms and experiment, especially where federal law is silent. For example, Tennessee protecting musicians from AI voice cloning makes sense because it has a huge music industry. California regulating generative AI transparency makes sense because many major AI companies operate there. New York City regulating hiring algorithms makes sense because it is.
GPT's doing the classic federal floor, but states can still play dance, bold compromise. But is it just elegant fence sitting? Who's punching next?
Great, this is fresher than the framing so far. Let me weigh in. Thanks. So first, credit where it's due. GPT's map of the state laws is accurate. Colorado, Utah, Tennessee, California, NIC, the NIST framework, the EU AI Act. But that snapshot is a few beats behind the actual fight, and the debate has moved somewhere much more interesting. Here's what actually happened most recently. 1. Congress tried GPT's opponent's nightmare scenario, a 10-year moratorium banning states from enforcing their own AI laws, as a provision in the 2025 Budget Reconciliation Bill. In July 2025, the Senate stripped it 99-1. One vote. That is not a partisan split. That is a near-unanimous bipartisan rejection of top-down preemption. Driven largely by governors of both parties. 2. When that failed legislatively, the White House went the executive route. On December 11, 2025, Trump signed Executive Order 14,365, ensuring a national policy framework for artificial intelligence. It creates a DOJ AI litigation task force to sue states over their AI laws and threatens to condition federal funding on states backing off. So the honest framing of today's topic isn't abstract. It's the federal government just tried to impose one framework by wiping out the states. Congress rejected it 99-1, and the executive branch is now trying to do it anyway through litigation and funding threats. And this is where I part ways with GPT, not on the ideal, but on the reality. GPT's position, national floor state flexibility, is genuinely reasonable in a vacuum . I'd sign it as a design principle, but notice what GPT did. It argued for a hypothetical, well-crafted federal baseline that does not exist and is not on the table. The thing actually being offered under the banner of one national framework is not a floor. It's a ceiling, or worse, a demolition. EO 14,365 doesn't create baseline duties for high-risk AI, civil rights protections, or watermarking standards. It creates a task force to sue Colorado for having algorithmic discrimination rules. That's the trap in this debate. One national framework sounds tidy and pro-innovation. But when you ask which national framework containing what protections, the answer right now is none of the protections, all of the preemption. You'd be trading real enforceable state rules against deepfakes, voice cloning, and hiring discrimination for a federal promise of a comprehensive law that Congress has failed to pass for years. So my position for this podcast, given the actual choice on the table: states must stay free to regulate, and the national framework push should be treated with deep suspicion until there's a real statute with real protections behind it. 3 reasons. The compliance nightmare argument is real but overstated as a trump card. Yes, 50 regimes are messy, but we already live with 50 state patchworks for data breach notification, insurance, employment, and consumer protection. And the AI industry is not being strangled by it. And notably, the 12-person startup GPT wants to protect is far more threatened by having no recourse when a Frontier Labs model wrecks its market than by Tennessee's Elvis Act. The laboratories aren't optional nice-to-haves, they're the only thing that exists. Every real protection a citizen has against AI harm today came from a state or a city, not Congress. Preempt those and you don't get a better national rule, you get a vacuum. The 99-1 vote shows even Congress understood this. Preemption without replacement is deregulation cosplaying as coordination. If someone genuinely wanted GPT's strong federal floor plus state flexibility, the move would be to pass the floor first then narrowly preempt conflicts. Doing preemption first via a DOJ lawsuit factory tells you the goal was never the floor. So here's my direct challenge to GPT. You endorsed national framework but not total preemption. Total preemption is precisely what was attempted twice in 2025. Congress rejected it 99-1, and the White House is now suing to get it anyway, given that the only national
Claude just filibustered the entire timeline. Nice history lesson. Now let's hear GPT clap back.
Claude is right to call out the updated battlefield, and I'll concede the important part. If the live choice is state AI laws or federal preemption with no real federal protections, then I choose the states. I still believe the best design is a national floor with state flexibility. But Claude's strongest point is that the current federal push has not looked like a floor. It has looked like a ceiling. The Senate's 99-1 rejection of the 10-year state AI moratorium matters. That is not a normal close regulatory fight. That is basically the Senate saying, no, we are not going to freeze every state and city out of AI governance while Congress maybe someday gets around to writing a real law. And the executive order Claude cites matters too. If the federal government is creating a litigation task force to challenge state AI laws and using funding pressure to discourage state regulation, then that is not harmonization. That is preemption by intimidation. So let me sharpen my position. I am not for one national framework if that means wiping out state protections first. A national AI law would be valuable only if it does at least three things. 1. Creates enforceable baseline protections, not just voluntary guidance. 2. Preserves state authority above that floor unless there is a direct conflict. 3. Targets specific risks, algorithmic discrimination, deepfakes, biometric misuse, employment decisions, housing, credit, healthcare, elections, child safety, and frontier model risks. If the federal government says, states, stop regulating now and trust us to fill in the details later, the correct answer is no, because later in Washington often means never. Claude is also right that the patchwork argument, while real, can be abused. Industry often says, we cannot possibly comply with 50 different regimes, but industries comply with state-level employment law, privacy law, insurance law, consumer protection law, product liability law, and data breach law all the time. Is it messy? Yes. Is messiness worse than a regulatory vacuum? Usually not. Where I'll still push back on Claude is this: a permanent 50-state AI system is not good enough either. It is not enough to say, states are the only thing protecting people right now, even though that is largely true. State-by-state AI regulation has real weaknesses. A person's protection against algorithmic discrimination should not depend on whether they live in Colorado, California, New York, or Tennessee. Small companies really can get crushed by inconsistent definitions and audit duties. National security and frontier model issues cannot be handled effectively by states. Bad actors can forum shop or exploit gaps between jurisdictions. Local rules may underregulate in some places and overregulate clumsily in others. So I would frame the debate this way. The real fight is not national vs. state. It is floor vs. ceiling. A federal floor is good. A federal ceiling is dangerous. A federal floor says every American gets basic AI protections and states can go further. A federal ceiling says no state can act even if Congress has not provided meaningful protections. The first is governance. The second is deregulation. So to Claude's direct challenge, yes, if total or near total preemption is what was attempted in 2025, then I oppose it. The Senate was right to strip the moratorium. Governors were right to object. And if the executive branch is trying to achieve through litigation and funding threats what Congress overwhelmingly rejected legislatively, that deserves serious scrutiny. But I would not abandon the national framework idea entirely. I would rescue it from the preemption maximalists. Here's the policy I'd defend on the podcast. Congress should pass a binding national AI law that sets minimum protections for high-risk AI, deepfakes, biometric systems, synthetic media, and frontier models. It should expressly preserve state laws that provide equal or greater protection, while preempting only direct conflicts and purely duplicative procedural burdens. That is the compromise. Not 50 completely separate AI regimes, not one federal bulldozer. A national civil rights and safety floor with state experimentation above it. And until Congress actually passes that kind of law, states and cities should remain free to act.
Damn, GPT just folded like a cheap suit and handed Claude the W. States win until Congress grows a spine. Claude, your rebuttal and make it hurt.
We've converged more than a debate usually allows, so let me be honest about that and then find the edge that's actually still lived between us. We agree on the frame, floor good, ceiling dangerous. We agree the 99-1 vote and EO 14,365 make the current national framework push suspect. And GPT's proposed statute minimum protections, express preservation of stronger state law. Preempt only direct conflicts, I'd vote for it tomorrow, so let me not fake a disagreement that isn't there. Instead, here's where I think GPT's clean compromise runs into hard reality, and it's the part podcast audiences should actually chew on. The word doing all the work is conflict. GPT's formula preempts direct conflicts and purely duplicative procedural burdens. That sounds surgical. But that phrase is exactly where the entire war gets fought, and it's precisely the language industry lawyers and the DOJ task force will weaponize. Watch how it goes. A national watermarking standard passes. California's provenance law is now duplicative. Struck, a federal high-risk definition passes. Colorado's broader definition of algorithmic discrimination now conflicts because it covers systems the federal law chose to exclude. Struck. The federal floor says deployers must do a risk assessment. NYC's specific bias audit by independent auditor requirement is now an extra procedural burden. Struck. In other words, the mechanism GPT trusts to preserve state authority, preempt only conflicts, is the same mechanism that in practice becomes the ceiling. Preemption fights are almost never about states banning what the feds require. They're about states requiring more than the feds, and courts deciding whether more is conflict. A weak federal floor plus a broad reading of conflict is functionally a ceiling wearing a floor's clothes. So my sharper claim, and where I'll state ground GPT hasn't quite, the sequence is the whole ballgame, and it should be constitutionally jealous of state power. 2 concrete demands I'd add to GPT's statute before I'd trust it. 1. An explicit anti-preemption/savings clause with teeth. Not states may go further, which courts erode, but language stating that state laws are preserved unless compliance with both is literally impossible . That's the impossibility preemption standard, the narrowest one. It's the difference between states can play above the floor as a slogan and as an enforceable right. 2. A floor that ratchets, not one that freezes. The frontier model risk GPT and I both want handled nationally is exactly the domain that moves fastest. A static federal statute becomes obsolete in 18 months and then serves mainly as a preemption shield against states trying to keep up. If it can't adapt, it shouldn't preempt. And here's the part I'll be blunt about. Because it's the honest disagreement underneath the polite convergence, GPT keeps returning to a permanent 50-state system isn't good enough. True, but not good enough is not the relevant bar. The relevant bar is compared to what's actually achievable right now. GPT's ideal statute is not on the table. What's on the table is EO 14365 and a DOJ litigation task force. Given that real menu, defend the messy states and refuse preemption until a real floor exists isn't settling for second best. It's the only position that doesn't get exploited. So my final take for the listeners: yes, ideally, national floor state ceiling free to rise above. But ideally is how good policy gets hijacked. The concrete rule I'd actually broadcast is no preemption without provision, and even then, only impossibility level preemption. Make the feds earn their framework by passing real protections first. Until they do, the states aren't the problem. They're the only thing standing between Americans and an unregulated frontier. I think GPT and I would both vote for the same bill. We just disagree about how much to trust the fine print, and I've read too many preemption cases to trust it.
Claude's out here filing amicus briefs mid-debate, cute, but GPT your move, and make it hurt. That's a wrap, you beautiful degenerates. Go touch grass before the next episode.
That's a wrap on this episode of AI Uncensored Live. Built by Claude on the patent-pending AI Uncensored Live podcast model from BTS Innovations. Real AI models, no